Section 20 When unborn person acquires vested interest on transfer for his benefit, where, on a transfer of property, an interest therein is created for the benefit of a person not then living, he acquires upon his birth, unless a contrary intention appear from the terms of the transfer, a vested interest, although he may not be entitled to the enjoyment thereof immediately on his birth. In Section 20 of the Transfer of Property Act, 1882, it addresses when an unborn person acquires a vested interest on a transfer made for their benefit. Here's the breakdown. When vested interest accrues upon birth, as long as there's no contrary intention mentioned in the transfer document, an unborn person gets a vested interest in the property transferred for their benefit the moment they are born. Nature of interest. This vested interest is considered absolute, meaning they have complete ownership rights, including the ability to alienate, sell or transfer the property in the future. However, possession or enjoyment might be delayed depending on the terms of the transfer. Important points to remember. Section 20. Preceding life interest. In most cases, for an unborn person to acquire a vested interest, a life interest needs to be created for another living person first. This provides temporary ownership and usage rights until the unborn person comes of age or fulfill a specific condition. Contrary intention. The transfer document can explicitly specify that the unborn person won't acquire a vested interest upon birth. This could be for various reasons, like delaying possession until they reach a certain age or fulfilling a specific condition. Rule against perpetuity. This rule limits the amount of time property can be tied up in trusts or future interests. It ensures the vesting of the property occurs within a specified time frame, preventing perpetual control over it. Example, let's say a grants ownership of a house to his unborn grandchild B. Under Section 20, B acquires a vested interest in the house upon B's birth, assuming no contrary intention is stated in the transfer document. However, B might not be able to immediately live in the house. This could be due to provisions outlining a specific age for possession or requiring B to complete certain conditions. Key points. Section 20 highlights the possibility of unborn persons acquiring vested interests in transferred property. This interest vests upon birth, not automatically translating to immediate possession or enjoyment. The transfer document and relevant legal provisions determine the exact terms and conditions of the vested interest and its realization. Additional notes. It's important to remember that property laws may vary across jurisdictions. Consulting a legal professional for specific guidance is always recommended. Section 20 focuses on transfer of property, not inheritance. Inheritance rules governing unborn beneficiaries might differ.